to drink food wine to keep his shaking from stop shaking. So that's a big no-no. Apparently, he also did acid and snorted Adderall that he got from his cousin or brother maybe. I think it was his brother. So to me, that's not a good sign, and maybe these people should try and do a little drug test on this guy. Justin is a liar who lies. Yes. Thank you. Hey, Miss Nancy. War on words. No, don't make love, not war. Hey, Finch. Justin went crying to mom and dad after the party, and they are the ones who set this all up. Yes, I have the same feeling that that's what have happened, because you have them. The restraining order is written almost so you can just go in and see what is a restraining order and how do I get one on the Massachusetts. What is a restraining order with the law? And you can see it's almost written exactly so it can hit that. It's the same when we write to YouTube and say, hey, we got a shitty copyright strike on my channel, remove it. There are certain words that you need to use, and you have to cite the DMCA rules. It'll go a little bit easier if you do all of that. And I feel it's the same here, because the family knows how to work the system. So the family most likely helped Justin make this because it's important for them to have this baby. And again, I can't wait to hear what happened, but we won't hear that because it's part of the it's part of their civil case or their family court case, which won't be televised. So we'll have to rely on, hopefully some of the locals will go to court and cover that when that comes up. But there's a lot of stuff from that bachelorette party that I can't wait to see those explanations, because Justin has this explanation that Kelsey lost her ever-loving shit that night and attacked him. First she was angry, then she attacked him, and he was really calm, and he just wanted to go to bed. And then she wanted to have sex with him, and he didn't want that. And then when he tried to leave, she attacked him and punched him 3 times in the face, and then he left the house. That's his explanation. Kelsey is, he had been really weird, and he was getting into a fight with her, and she wanted to leave. And then you have the bridesmaid who said, I heard Justin's sister screaming, leave my brother alone. And apparently there's another witness who also is a bridesmaid, but I haven't read her statement. But she stated that Kelsey was acting up at this bridal shower as well. So there's so many stories, but that'll be part of the family one. No meltdown coming today. I am absolutely calm. Look. Super calm. This is my streaming hand. Oh my, oh my, oh my. We have court feet. How nice. We don't have court feet anymore. Well, we did have court feet for a second. So that'll be back. It'll be back. If you can just kill the chat, then it will be perfect. Because the little X up in the corner, it's a new thing on YouTube. You have to, no, just full screen it and then, yes. Look at this. Teamwork makes the dream work, as they say. Linda, you are not late because we just got a feed through to the courtroom in the Kelsey Fitzsimmons trial. Wanda Marissa is doing it again. This case makes me more angry than Karen Reed. Yes. Gabriel is delaying the hearing. Yeah, I see he's out there. Randall is also streaming. He's beating our numbers because he has Jay Brill on his channel. I need a Jay Brill. Nope, don't do the drama, Baker. You've said it. But this case actually makes me really, really mad because in the Karen Reed case, it was just cops protecting cops. In this case, you have all of these a-holes from the police station. You have boss's girlfriend, Wolf, who is, hey, Justin, we're thinking about you. We know this is a hard time for you. Oh. And then you have Miss, I didn't do a roid in my life, but my chin looks like it, who is on private messaging with the mom saying, of course we can send an extra patrol out to check your house tomorrow. Yeah, we'll protect them. Sending out an email claiming that Kelsey did fire a gun at Noonan. Yes, now you can relax. And if you just, unless they're playing music, just take the audio off. You can go sleep. It's Mother Hardy. My favorite part of the Jack and Jill party story is how Kelsey was chucking stuff at every single person there, but never managed to hit any of them and leave a mark. Show me such marks, my young man. Well, allegedly, she kicked someone twice. But I love that Kelsey leaves the house at around 11 if I read that witness story. That witness will then stay there till 1 or 2 at night where there's so much commotion in the house, she says, no, I'm effing leaving. And they called Kelsey's mom and dad, who says, no, she's fine. Don't you worry. And then on the way home from that, Kelsey is trying to kill her by running her off the road. Well, she couldn't see who was in the car, but that's what she's trying to imply. I'm just calling what on all of that BS. I'm still torn on all the Kelsey stuff. I think she's been done dirty, but in no way is she a good person. I don't know if she's a good person. I don't know her personally. I know according to the statute that she is charged with, she is guilty. Because any brandishing of a firearm in front of a police officer in Massachusetts is an attempted assault with a deadly weapon. No matter what you do with it. And that's why you need this to go in front of a jury instead of taking a bench trial. Because a jury will look at this and say, well, that's just bullshit. She clearly tried to honor life herself. He wasn't threatening this cop. She never got a pew-pew off, and he pew-pewed her twice. You need the sympathy in this one, because if you it's the same with the witness intimidation charges Aiden is charged with. It's so overly broad that you cannot not be guilty. And that's why you need a jury to come in and say, technically, yes, but morally, absolutely not. Because that's in no way how it is in this case. Because as I see it, a jury will have a hard time finding her guilty when all of this. I would even though I say never ever take the stand, I would say she should take the stand in this case. But she was a cop too, and he pulled out his pew-pew. She was not on duty, and that's the difference. He was being served upon. Apparently, they are moving everyone to a different courtroom. Must be more people there than the court anticipated. I haven't seen. The only picture I've seen from outside is Jay Brill, and he's talking to some guy, and I'm not giving Randall any views. F you. But I don't know if there's been. I know Aiden is there today. It seems like this case is picking up more and more attention I can tell in my numbers that more and more people are looking at it. So especially now with all of the family court stuff coming out, you're beginning to have a lot more stuff to talk about. Oh, the elevator is broken, which is why they're switching to the first floor courtroom. Oh, we thought it was because she had so many people there. Mary, you just ruined she got a lot of support. The joke. Yes. I agree. Anyway, we put it, her pew-pew was there, but exactly everything around it.
This will be the only and final warning when it comes to the usage of phones. So if you take out your phones or you get a message or anything and you can call or send a text, please do it outside, do it in the session, kick you out, and you will not be allowed back in. Okay? This is a public hearing, it is a public courtroom, that is until you start violating policy or going within the courtroom. Okay, so if you do that, you can get discretion.
No, just keep the audio on. Let's see what happens. This was just instructions given, turn your phone off. It's fabulous that Justin and his dipshit behavior is what brought so many eyes to it. Yes. Yeah, steady that, Cam. And apparently the Commonwealth brought on another lawyer yesterday. This is going to be 2, maybe 3 days in court. I have sat with trials in Denmark where we have 16 days in court and we just have one prosecutor. Why do you need 2 prosecutors for this is a simple case. Did she pull out a pew-pew and was it in intent to harm Noonan? Why do you need 2 prosecutors for that? Thank you so much, She's Like Texas, for coming. 20 member bombs. Most talkative. 11 stays 1. And then Janelle. Rose Plitzkas. Amber Hamilton. Hammers. Laura. Hanky Panky Mom. Jules. Maxter. Sarah Smile. Lauren Tedford. Kelly Chloe. Angela. Kennedy. Gabby Campillary, maybe? I don't know. Jeanette. Derek Cossan. James Moran. Miss White, 8. We're all lucky enough to get one of the amazing memberships gifted by She's Like Texas. Thank you so much. She's like always very friendly with the member bombs. I have my glasses on and I can't tell who is sitting over there. So, hard to breathe just looking at that small room. This is a big courtroom. Is it Kelsey sitting over there behind the short-haired lady? No, wouldn't she be at the table if she was there? I don't know if she's there. Hey, Jay. This is ridiculous for simple assault. Then making a big spectacle of most that she can get is probably probation. It isn't simple assault. It's aggravated assault with a deadly weapon against a police officer. But yes, probation most likely. Hey, Danette McClure. I can't see Kelsey. I think she's between the suits. No, that's her lawyer with the long blonde hair or gray hair, whatever it is. Yeah, There's the guy with the white hair, and there's a lady with a black top. Yes, good work, camera guy. Let's see that one. Yes, that's her behind her there, right? I'm pointing on my screen, but I can't do that because it's Marissa's screen. I think she's in the pen. Jesse Beanie, thank you for showing up and watching my show. Yes, that's her in the background with the brownish up. Oh, I got it right. It was brown. Any DA would just make a deal with her for probation and have it done. Sorry, anyone with a touch of judicial economical thinking, that's it. Linda, you forget there's something going on here, and this is why we are all here today. 180 people are sitting here watching a stupid Danish guy talking about this because they're wondering what the F is going on. Why don't they just say, yeah, you suffered enough. You spent 50 days in prison. Just sign this. Maybe she didn't want to take a plea deal. I don't know if she's been offered a plea deal. I don't have direct contact to her or the family. Marissa is... Have you tried Snickers? Someone turn off the Zoom audio. Remember, the camera guy probably had everything set up perfectly for the other courtroom, and then he had to go down here. So now he's trying to get the best shot he can get. Maybe Aiden wasn't allowed in. Maybe there's a limited number of seats. We saw that in the Karen Reed hearing, where we thought that's pretty full. Apparently, there was at least as many people outside waiting to get into the courtroom. So I think that could be why Aiden isn't in the courtroom today. Maybe the cameraman was setting it up with Justin before he went into work. Could be. No way they offered her a deal. Certainly not a deal one could accept. Well, that could be the problem. Maybe because you want to keep her police license. She can't have a felony. I don't think it's a felony. She's been charged with. Yeah. Yes, I believe that is Mr. Stephen Fitzsimmons, her stepdad, who is sitting next to her, right? If she has an opportunity for this to be eliminated from her record, having a clean record, it's worth not taking a plea, in my opinion. It depends on, again, all the circumstances. Most times, it'll probably be easier to take a plea deal and save a lot of money. And again, let's thank Masa for being one of the absolute G's who has made sure that at least 100,000 of the money she needs to spend on court has been covered by all you wonderful people. I can do this, I think. Yes. I put a QR code up there if you want to support Kelsey's fundraiser. There's a QR code in the top corner that should be leading. Maybe one of the mods can find the link to Kelsey's so we can pin that on the chat as well. I hope Masa gets a big bucket of chicken wings at the least for all he's done. Masa has been absolutely wonderful. And Lauren, I really like her. She's a breath of fresh air coming into it as well. And I like how, contrary to the Free Karen Reed movement, this has been a very pleasant group of people to be around. It hasn't been all of that drama. I've seen that the Twisted Tragedies, who now calls herself Untwisted Tragedies, is also covering this. I have said I would not do as much Massachusetts anymore and make fun of these idiots who has been anti-Karen Reed. So I haven't watched it because it will just drag me back into all of the drama. But I don't know what her take on it is. But I guess because Aiden is pro Lindsay, pro Kelsey, that she hates her. He does some really nice chicken wings. It's I don't like chicken. Well, I do like chicken, but I don't eat chicken because I had salmonella poisoning once really badly. And when he puts up those, when he makes wings and put it on Twitter, I'm so, wish I could eat that. We haven't watched any of that. Jay Brill is an idiot. I wonder if Aiden isn't in the courtroom because Bradle is there. No, that would have no bearing. That would not be a conflict in any way. Their cases are not interlinked, so it would have nothing to do with anything. Aiden is inside the courtroom for the final pre-trial hearing in the Kelsey Fitzsimmons case, which is scheduled to go to trial on March 23. Kelsey has a good support system here and is seated next to her father and a doctor who I believe will be a witness for the defense. Justin pretended to be scared to death of Kelsey's dad when he demanded a taxpayer-funded police detail while he broke into Kelsey's home and stole her personal property while she was fighting for her life in hospital, is what Aiden just wrote on the twit. So he is in the courtroom. He should have his journalist credentials, so he could sit in the press box. Can we find something on why Julie Grant was fired and cover that? Julie Grant was fired because Lorne and Krim has bought Court TV, and it's probably because she want to go on to newer and bigger endeavors. Isn't that what you write in every paper when you say, you're a fucking moron, you're fired? I love that both Runkle and Betterow has been out there saying, well, Court TV just got way better because she was a moron. The lie of cops can't be a cop if convicted of felony is BS. Many cops in the U.S. have felonies and are still cops. Want names? No, Jason, I know you have a hatred for cops. I don't have a hatred for cops. I have a hatred for dirty cops. And I know you have a mission that, I don't know if you want all police departments to be dismantled or something, but I don't need any names. But thank you so much. Pretty sure I was blocked by her a while ago for correcting her BS. That's the same thing that Betterow said. He reached out and tried to have a conversation. No, Betterow reached out to try and have a conversation. She instantly blocked him. I was blocked by her as well. Oh, Lorne and Krim is just as bad as Court TV. But it'll hopefully give more coverage because a lot of days Court TV and Lorne and Krim are covering the same. So if they can get more trials up and running, so you have more trials to watch, because right now everyone is watching Corey Richards or this case. It could be nice if there was 4 live trials at the same time. So you could say, no, I don't want to listen to Corey Richards. I want to listen to, like I'm covering that nurse case. And then you could pick and choose. I'm all for making the cake bigger instead of just everyone is covering the same thing. Yes, she has supporters right behind her, and I'm glad. And you can see purple is the color they have chosen for the Kelsey movement. I met Julie Grant at CrimeCon and I took a picture with her, and when she didn't know, a post with a pink duck. That would have shaved her buttocks. I'm blocked by Julie Grant, so I got blocked during the Karen Reed one because I pointed out she was wrong about. I think she directly misquoted a witness, and I said that's not what they said at all, and I got blocked. I don't watch Court TV or Lawn and Crim's. I don't watch Vinny or any of those shows because I do true crime myself, so you get kind of burned out. So I don't sit every night and watch Bronco, even though I love the guy. I'm just burned out from watching true crime all day myself. But every time you'll swing by or you would see her on Twitch, she was so heavily biased. And I know a lot of people liked how Sue from Boston covered Karen Read, but I can't stand her. It's she's so highly biased in every position, and I don't like when journalists are that biased because they go out there and say, well, we're journalists. We can put our biases aside. No, you can't. That white-haired chick is Courtney. Can't believe that chick hasn't been fired. Neither can I. She must be really, really good at being a paralegal or whatever her position is, because what she did is horrible. In the past, I didn't care what's both, but there have been so many weird panel shows on, so recently I decided not to give the views. Just when you bring Plevin on as an expert, you cannot be a credible news source. I can do whatever I want. I can bring Sue on and sit and talk about it because I'm a effing YouTuber. I don't pretend to be anything fancy. I'm not a lawyer. I'm a clown. But they are sitting there like, oh, we have this former lawyer on, and then they have Caffey Daffy on. Caffey Daffy, who is now the number one go-to in the Savannah Guthrie case. The woman who hasn't been right on anything all the time I've seen her. Yeah, Sue is quick to always say she's a commentator, so she can be biased. Yeah, but then she will still go in there and use her NBC 10 or NBC Boston moniker so she can seem not biased. Hey, Lynn Dalton, good to see you. You have been away. Oh, but glad to see you back. Yes, we just read his tweet 2 minutes ago. Oh, there it is. Again, I just pinned the fundraiser to the top of the chat as well, if anyone wants to go support Kelsey, because not only does she have this criminal case, she also have her civil case where there will also be a lot of funds that has to be used on that, because you saw what we covered just yesterday. So she has to sit behind them now. That's weird. But I'm sorry, and I might be mistaken, but when I see those two police women who were fawning over Justin and his mom, I just see they are envious of her because she is a pretty woman. She there's no ifs, buts about it. But no one hates a pretty woman as much as another woman. Thank you, Empire. Baker, have you seen the video of cops plant meth on innocent man? They recorded themselves doing it. When defendant asked for body cam, they sent him the wrong one and sent the one of them doing it. No, I haven't watched that one. I don't watch a lot of the body cam videos unless someone tells me, hey, have you looked at this one? So, but that's the thing in this case, because people are saying, well, they wanted to unalive her. And they could just have done that when she was down. Just go over and put one in her dome and finish the job if that was what they wanted to do, and then plant a pew-pew at the scene, because Justin has access to the gun safe. They could just have put a gun next to her if it was a hit. That's why I don't believe that story, that it was a hit. Well, it's because we get bored of watching the same stuff everyone else watches as well. So that's a good thing. Well, I don't say women are evil, but I just know there's a lot of catfighting going around, especially if you have who is objectively a beautiful woman. Have you looked at the two officers? Don't cut the feed now. I always say to my wife when she gets dressed up, she does it to impress other women. I love her in sweatpants and a hoodie. Again, when I saw that picture of Justin's sister yesterday with the fish mouth and the weird eyebrows, and apparently she was trying to get some work for a talent agency. Do I have that readily available? Whip, 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 whip. I do have it readily available. Because now they just caught this. So hell. I can't add to states because it's I'm gonna remove this and then I'm gonna add this. This is on exploretalent.com, which seems, if you go and look at the website, kind of like a scammy thing where you pay them to be your talent agent and they'll find you work in the business. I don't know what kind of movies she is trying to get auditions for. I'm just saying it doesn't look like she's going to be opposite Leonardo DiCaprio in the next movie. Boom, boom, boom. Is there an Abington in Mass? How would I know? No, that is Ashley Alien, Justin's sister. Yeah, and the feed just dropped. So yes, Abington is on the South Shore. You're still straight after seeing that. Hello, Ruth. No, I don't think she's trans. I think she just had a lot of very not good work done to her. I'm not a big fan of the puffy lips, and I don't know any man who really are a fan of the puffy lips. But it's a thing you ladies do to yourself. I have never met a man who said, I love my wife, but I wish she looked more like a deep sea fish that had been dragged up from the deep. That was Justin's sister, yes. That was allegedly the one who was in a fight with her at the bridal party. Maybe that was a filter. I bet you there was more than one filter on that photo. Hey, Mullen-Law. Great to see you. Mhm. Why did they take the fee down?
I talked to Officer Newman. He said he had nothing to hide and he is not, and he's willing to turn over his IA files. I told counsel that I would personally reach out to the PD, request those, have Officer Newman give them permission to turn them over. If they somehow
This is
need
on Law
a
Girls
court order or
Attorneys.
something,
Go give
I
them
would
some
come
love.
to the court just to ask for a court order, but otherwise,
Okay.
I think we're fine there.
Okay, so, all right, so that's good news. I don't want to meddle, at all, but, I'm just concerned that but we're running out of time, right? And we're only a week and a half away from the start of the panel, if I have it correctly. So, and I'm concerned that if an order is necessary, that it will slow down the production of it. So does it make sense for me to issue something that would?
I'll find out today. I'll call today.
Okay, all right. And so with respect to that, we wouldn't need, we would just have a return date on the order on the summons for the records. And it would be.
If that's necessary, if they'll just turn them over to me,
Okay.
that's what I anticipated, that would be quicker.
Oh, okay.
And then, we can litigate if it's coming in or not at some other point, if there is anything.
All right, but let me make sure that we're all on the same page. Mr. Brandon.
I'm okay with that.
So you're okay understanding that the records are going to go through the district attorney's office?
I'm okay with
All right, and not the court. Okay. All right. And then, so you folks have proposed a protective order on the, agreed protective order regarding dissemination of discovery materials in the empowerment of motion and affidavit. So is this broader than just the Officer Newman's records?
No, that's just your office in the
Do you want me to put this, sign this?
And Judge, we talked that this is applicable to both Lawrence and Northampton.
You're right. So paper 70 is the motion for production of the Lawrence records, and paper 71 is motion related to North Andover. So I can mark those as allowed by agreement of the parties or pursuant to agreement of the parties for now.
Well, I would not, because it's not every paragraph is
Okay.
agreed. I would just,
So
council's okay.
That's fine. We can say that I'll say in open court that I agree with counsel's protective order, the scope of the records as reflected in the protective order.
okay, all right. All right, so we'll work on the details of that. And then as for this protective order, I don't want to slow things down, but I do want to read it before I sign it. So I will insert wants to put that in the pile for you to review. All right, so then that leaves paper 69. Which is the defendant's motion for production of third-party records from the North Andover Fire Department related to Mr. Elaine.
Elaine, that's correct.
Elaine, is that right? Okay. Let me just say, I did have a couple of questions for you folks before I turn it over to you, Mr. Brandon.
Sure.
Does the Commonwealth intend to call Mr. Elaine at the trial?
Yes.
And
Can you unmute it?
to call Mr. Elaine at the trial?
Yes.
And
All right, so I guess a couple of observations, Mr. Grado, then I'll turn it over to you. One is that your affidavit in support doesn't mention Mr. Lane at all. So I'll just point that out to you. Also, the proposed order doesn't mention him either, or who the subject of the records would be that would be ordered to be produced. And also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or at the end of the day. I couldn't get the other phone to open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Lane is observed on this video. I assume that their residence at the time smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this could be relevant to Mr. Lane's ability to perceive the events and hear the events accurately and then relay them. So, but how is, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Elaine, drinking a glass of whiskey or a beer, the number of times that you saw him.
What's the difference?
Right. What is the difference?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances.
Maybe 270, I'm being a little conservative, but over 200, let's say.
All right, over 200 instances of.
What you see in the representative sample.
Okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30th incident?
Correct.
Okay,
Correct.
all right. And this is something that that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had that they returned to us recently.
Okay.
So they definitely have everything. And so, Judge, it's fair to say that there's a pervasive marijuana use by this guy.
Okay.
And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number 1. Pages 37 and 38 of the town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this, I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera, and testify credibly. But what is the evidence that on June 30th, that whatever time in the morning it was when this incident happened, that Mr. Elaine was under the influence of something at that time?
So, Judge, it was the afternoon, and the idea is that, the pervasiveness of the usage raises a legitimate question. And this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question. And I would venture to say that the standard there is that is something.
I'm sorry, Steve.
Yes,
sir. But the case was clear is that this can't be, I just was reading Commonwealth versus Jones, I think, which is clear that this can't be, Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to know that the evidence would be admissible.
Yes.
Right? So
Well, I mean, it sort of is a discovery tool in the sense that we get the documents early. And in order to get the documents early, we have to make a showing. And I think the showing is made, Judge, in terms of relevancy of his ability to proceed and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number one. Certainly a problem with this guy. And number two, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 37, 38 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis to say, give us this early, Your Honor, that if he's been tested at work and he tests positive at work, he's been given breaks at work, he's been put in rehab from work.
But how would that be admissible? So that would,
So
let's assume even 2 days before, on the 28th, his screening came back at his employer for positive for THC.
sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, were you smoking on when this happened? Do you remember these events accurately? Do you even know what you were doing when you were in that basement? Do you know, you're taking your baby under the influence of marijuana?
You don't think you have that good faith basis to ask that question now?
Well, there's always,
200.
I don't need to tell you, Your Honor, trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, ultimately it would be a discovery matter to get this stuff. But, the lawyer is always at the mercy of someone saying no. And then if you have the backup, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive his marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant standard, the lack of fishing expedition. We can't get this material anywhere else. This is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. I always have in mind, Judge.
But again, I'm not sure that the records, again, the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is
Thank you, Skip.
keeping in mind that you're asking for me to order production of records, of employment records. Again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Elaying's state of mind was at the time of this incident.
Well, I think you gave me my answer when, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200 something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, okay, so then we have town policies, and then there's also another law, Judge, that's Chapter 40, Section 101A. It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or firemen. So,
Mr. Gray, all of these statutes that, again, I don't take issue at all with, I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off, and can affect someone's ability to proceed and then relate what they saw or heard on the scene. it's the idea of getting records, that you are fishing for, arguably, no? Because,
So-
hold on, again, I'm constrained because the case law, says that this is not to be used as a discovery tool. Now, let me say this, I've been there before, and I know that you're between a rock and a hard place, because you have some information like you do about the possibility that they'll be in the records, but the SJC has made it clear that you need more, I believe.
So you're the judge and I respect your ruling, but I should just say.
Well, I haven't ruled yet. So
I appreciate it. My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if we could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, that's never the case because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where, you have a time machine, you have a magic wand, whatever you want to call it. We don't know. Defense counsels never know. And that, it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I'd answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all a defense counsel can ever have is kind of skirting around the edges. And
in fact, arguably, you have more than we often see, right?
I think so, Judge. So, this is just, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, who knows what he's gonna say? I don't know, because he's an adversary. So, I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that'd be my argument, Judge. Thank you.
Pablo?
Well, I think I just echo much of what you said, and so I hate to do that, and echo what he said. He said, maybe, we don't know. That's the definition of a fishing expedition. That's the definition of a discovery tool, and that's what he's looking for, and he felt admitted it. He has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that? He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is. And that's often the case. So I would suggest to you, he has not met his burden, and the court should deny the motion.
Mr. Gray, anything else?
No, Your Honor, thank you.
No, on that.
No, that's all I have for that, yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the land pond protocol. And as I said, I'll be more specific in my written ruling later. All right, now that's moves us to. All right, so, I thought we would then go to the defendant's motion in limine, which has various requests. Let me just get it from you.
Marissa, can you,
Number 67. Now, I meant to
The judge is kind of right in this. It could be seen as a fishing expedition. They have indications that he has a severe drug problem by having 207 videos of him that the Commonwealth also have of him using marijuana. And you will then say, but marijuana is just like having a drink. It's not a problem. Well, it is a big problem because he works for North Andover Fire Department that has a clear rule, not only the fire department, but the entire city, because of the way that their agreement is put together. They are not allowed to smoke, vape, or do drugs. But that would be more of a job-related problem. It's not a direct influence in this. This can go to his credibility as a witness. If he goes on the stand and says, no, I don't do drugs. Okay, let's see these 200 clips of you doing drugs. But having his record from the fire department could be looking like a fishing expedition. We just want to see what other reprimands he has so we can chase that down. Remember, the judge is also here to make sure that both sides are listened to. I still believe that this will be more important in family court than in criminal court, because Justin will be a witness in this one. In family court, he will be the adversary. So it's maybe not the most important part because he has no direct knowledge of the incident that day. So again, let's keep it for family court, where I think it'll have more weight.
Now, I meant to point this out even before we started on the Rule 17 motions, but I think it's worth saying. So, Mr. Gubitosi, at the last hearing, you said this is something to the effect, and probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in this particular motion, Mr. Gradle, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here, to trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So as for sequestration, let me say this, I typically don't issue sequestration orders like formally. In other words, I would ask the Commonwealth. I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses that how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes. Okay. Thank you. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order, that they're not to discuss their testimony with other witnesses. All right, and on number 2, the opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it also is binding on defense counsel.
Meaning what?
He also refer to anyone as victim, suspect, target.
So are both sides okay with the alleged victim?
Yes.
Of course, yes.
Okay. All right, so, I'll allow that. And I'll write this up later so that we're not, and number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this, it probably makes sense to hold off on this because I view this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me, Mr. Trey, and we can circle back. I haven't addressed everything.
Certainly.
In there. Number 4 is voir dire. Let me hold off on that for a moment because the Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth.
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer, I think that's kind of unavoidable. They're
But not a
literally-
repeat offender, that's what I'm.
Certainly not repeat offender. And I think the defendant did never fled anywhere. She was never a target of any, broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case, so there's no objection.
All right, so that will be marked as allowed without objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out. But we'll get to that in a moment. So that leaves paragraph 4 in the defendant's motion, which is request for voir dire. And while I'm addressing the defendant's request for voir dire questions of jurors, let me get the Commonwealth's out. Paper 63 is the Commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct individual voir dire of every juror, whether they answer yes question, any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney conducting voir dire. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include
Probation.
something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask, I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when I they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, et cetera. Same thing with age and I and J. So all of those things are kind of covered, but you'll be free to ask follow-up questions or questions that are that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, groups that may advocate for Second Amendment issues. I don't know, things of that nature. They could be grouped together, but I think K is too broad. So I'd be amenable to, again, asking for, if they've ever, if a juror, potential jurors ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a shared parenting organization.
Sentencing guidelines says probation.
Yes, I think we should do something like that. I trust your judgment to formulate that.
Okay, so on the Commonwealth's and paper 63, I think I cover almost all of this, at least on the first page. Second page. So it does make sense to ask about, as the defense requested, suicide, mental health, in general, postpartum, even. I can formulate some questions related to that. Training and experience with mental health issues. I don't know, is mental health going to be a issue? Well, it's going to come up at some point, right? Even on a limited basis.
I think it's going to be very tangential, Your Honor. I think it's really more about, and actually, my brother and I just hatched out an agreement that the way that this was served, as they all are, is without an affidavit. It was just served. The order was served, and I think we have a stipulation that we can just admit what was served, the restraining order, and the terms of the restraining order are what we both literally were just discussing this. What we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is, do you think I should stay away from 8, 9, and 10 and 11? Or do you, that being on a Commonwealth's request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10 because I think it's kind of suggesting things that aren't going to come up. Mental health disorders, I don't think that's really going to be something that's going to be discussed at this trial or ought to be discussed.
But you folks are asking about suicide, so wouldn't that beg the question? No? I mean, obviously there's many reasons that people commit suicide.
Not necessarily, I don't want to invite some sort of wide-ranging exploration of, Ms. Fitzsimmons's medical history. Not to suggest there really is anything that's, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child in the completely out of the blue. She's home with her baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiance. Her marriage is over, ain't gonna happen necessarily. And you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back. There was a 100-page report clearing her of anything and putting her back at work. she was going on the schedule in 3 or 4 days. And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and, expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted minute.
Okay. So the bottom line is you object, the defendant objects to 8, 9, 10. How about 11? Just the training related to mental health.
That one, we're okay with that.
All right, so 8 to 10. So let's just take them a bit at a time. Commonwealth, and from your perspective as to 8, 9, and 10.
Obviously, we cannot predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the same. When someone hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it, it's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Alien should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow. It could be a 1-day long trial. It could be much longer depending on how things go. So I think we need to really probe the jury and find out any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant. But as for specifics related to postpartum, so does the Commonwealth believe just in your case in chief that would somehow come out?
No, but I mean, there are signs outside talking about postpartum depression is not a crime. So it would be.
And at the end, how come I remember, I'm surprised that this, Mr. Grado, the postpartum depression is controversial from the defendant's end, because I thought I read in some submission somewhere that was a fact from your perspective, right?
So as we're evolving kind of towards trial, Your Honor, it occurs to me that the case is really doesn't matter much about why the person got an order, what was going on with these people. The police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten, or whether it's based on truthful information or fraudulent information. They have a duty to serve an order.
Okay, but let me ask you, tell me the facts about the service, the actual service of the order. And that is that, does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shoot?
Yes, you
Okay.
process the order, not the affidavit.
Not because the affidavit wasn't there. All right, so Mr. Grado, presumably, and you said this, is that your client's state of mind is significant, right?
Right.
Because she has to have intent,
Right.
right? And there was some mention in some filings about perhaps she was pointing the gun at herself. You asked about the suicide attempt. So I'm failing to see how just asking a question about postpartum depression somehow prejudices the defendant.
My
I'm
thought
not
is,
suggesting that it would be admissible or not,
Right.
it's just a question.
right. I mean, I'm concerned about the degree of disclosure, and I feel like, the second it gets mentioned, that the government's going to allege that we've opened the door to something, and that all of her prior incidents are relevant and now they have to come in about postpartum depression. So, you know, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, you know, we don't need to build a lily here on, you know, and when on top of that, she has a bit of postpartum depression. Like, I mean, how far do I have to go? I mean, those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health
I agree.
or conditions.
I agree, but I don't want to open the door. And if
You're not, so let's be clear.
okay.
We still need to drill down on, at least I think we do, on what is admissible broadly in this area. All I'm addressing right now is the simple yes or no question related to postpartum depression. And that is whether they have any experience. I could use something similar to Ms. Moriarty, were you in the Brito case, you know, where there was a significant mental health issue or issues. And it would just be yes or no. It's not, I would never say there'll be evidence that the defendant, it's just their experience with that.
You're giving me a comfort level, Judge, and I'm okay.
Oh, okay, but the other thing too is just understand this, is that I'm gonna take the information that we gleaned, that we discussed now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity to
Okay,
put that in there.
I'm okay with it.
And
Just give me a comfort level, Judge. I'm okay.
You don't need to be comfortable. All you have to be comfortable is that it's gonna be in the draft, and you'll have an opportunity to see exactly what I want to ask. And that's for all of these questions. But can I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire. Is I think that there's obviously media attention to this case, there's public attention. The public and the media have a right to and the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, for, you know, obviously to provide, show to your client, and just impound it until we get to, then we can talk about what we do with the final one as well. But any objections to that from either side?
No, I think it's a great idea.
Okay, all right, so, that's the way Mr. Williams says, remember, that's the way we'll handle that. All right, so I think that, does that cover everything? I think firearms related questions in Second Amendment type of stuff that I typically ask in a firearm possession case would be pertinent. Again, why don't you folks just with an open mind, take a look at what I write, what I draft, and you can object or take it out. Let me just look at the rest of this. Yeah, all of the rest of the questions would be included.
Your Honor, if I may add one that was not written.
Sure.
If you are going to reference, at least how defense counsel has it phrased, there may be references to suicide attempt. I think that is a way that gets the jury comfortable with the defendant's theory of the case. The Commonwealth would ask if that's the way it's phrased, that.
No, I'm shaking my head because it's not going, it won't be phrased like that. At least initially when I drafted it, I think that all of these questions have to be neutral. They have to be neutral to both sides, in fairness, but more importantly, again, it's not, I don't like asking questions that are case specific. The evidence may show. So So the issue is whether they have a personal experience with suicide, all right? Again, from the defense perspective, and that's what they'll be asked, something like that.
I would just like to raise the point of suicide suggests that the person committed the violent act themselves. The Commonwealth, one of the Commonwealth theories may be that it is an intended suicide by cop. So that,
Oh, okay.
so I just think that if Your Honor can consider that when drafting your questions.
Oh, so in other words, you'd like to, perhaps a question that would cover so-called suicide by cop?
Yes, sir.
Right, so,
Thank you.
just, I'm not sure that I'm that creative. I'll have the ability to artfully draft something like that, but we'll put a placeholder in there. I'll do the best I can, and folks will.
Just to chime in on that,
Sure.
I'm not crazy about that because it's too specific, too suggestive, and it just adopts the Commons theories. So I think the topical reference should be where it begins and ends. Just put my position.
Okay, so it seems to me that they're going to be asked, like in any serious case, whether they or a person close to them have been a victim of a violent crime. So typically I ask that, maybe, or been accused of perpetrating a violent crime. Maybe it needs to be shooting related, that question. Or firearm related or something, but again, I'll draft a few questions that I think are appropriate, folks will weigh in and we'll hammer them out. Anything else just generally on voir dire? On the juror questionnaire?
Okay.
And then, all right, what else did I want to say about I have to tell you, from my perspective, you folks tell me you know your case better than I do. I think that the impanelment will take 2 to 3 times as long as the trial. I'd really urge you folks, from taking a look you probably have at the rules of professional conduct as it relates to trial publicity, and just do your best to make sure that we can get from the start a pool of potential jurors that are indifferent to the extent that we're able to. But I hope I'm wrong, but I really think that the impanelment will get 14. I don't know. Anyone disagree?
I think that just depends on, what he potentially opens the door to. So. Yeah. About how long the trial will be.
Okay.
What he
I'm not
potentially
really
opened the
understanding
doors
that,
to.
but I'm not sure that I need to. So let me talk a little bit about scheduling. So I'm going to assume that we start the paneling on the 23rd. We get jurors here in Lawrence on Monday, Tuesday, Wednesday, Thursday. We get the most jurors on Monday, and then the amount that we get are less than each day. I think that we should assume that it will take through Thursday, and that the trial, I should tell the jurors, perhaps even in the questionnaire, that the trial would start on Friday or even the following Monday. I know you tell
We
me.
can think about that only because we only get 6 challenges each. So that sometimes makes a difference. I understand other challenges that we will be dealing with, obviously, as far as people knowing about the case and reading about the case and the like. But
I'm glad you raised the number of challenges, because I'm getting my water from you, because the last handful of trials have been like felonies, where folks get more. But my memory is that on the criminal side, you get 4 and 1 extra if there's going to be any extra seated jurors. Frankly, whatever the rule says, I'm going to give you. I know the council oftentimes tell me, well, in Essex County, judges typically do X amount. I don't care, whatever the rule is, and I don't have it in front of me, I think it's 5.
But we were just talking, I thought it was 4 and then a challenge for each extra juror. Of course, each alternate juror, so.
All right, I don't have my, but whatever we'll all research.
I agree with that, Judge. And then if there are 2 alternates, we get 2 more, so there's, typically 6.
I don't think that's.
Whatever you want.
I don't think the rule, I think the rule is for any that are over and above the 12, you get 1 more when it's not a light felony. But again, it will be 5 or 6. We'll figure that out. But I need to tell the jurors the start date. And I also need to tell the jurors an expected end date for them to get that, when they'll get the case. So what I was going to propose is that they be told that the trial would start again on, the actual trial, the evidence would start on that Friday or even following Monday, and that they would get the case by the following Friday, in April 3rd.
Why are we wasting time on this?
Which is over estimating the length of the trial on purpose, so that we have built in time.
Sure, I think we don't want someone going away. I totally agree with you. I don't know if it's going to take that many days. Maybe I'm being naive to find a jury.
Okay.
So, but we can maybe see where it goes. I mean, I think maybe we say we start on Thursday. And think about the day. And
Okay.
go from there.
Yeah, we can even tell them that we'll start on Wednesday or something. And see. I'm surprised. All right, but don't be surprised when you get a draft of the juror questionnaire that it says that I estimate that the jury will get the case to begin their deliberations. I'm just going to probably just default to April 3rd, which is Friday, because then in the next sentence I'll say that therefore you should be available to serve the following week in case it lasts longer. So let's talk about, in this meeting, we have more motions which we'll address, and this may be the subject of, let's talk from the Commonwealth's perspective. I'm trying to get a handle on what exactly the evidence will be related to the purpose of the police being there, how much you expect to get in during your case in chief about this custody issue that was ordered, et cetera.
Well, the underlying facts that I expect to come out is that a restraining order was sought. Mr. Alien was at the PD. He gave the restraining order to the officers. 3 officers went over to the house. He stayed back until they called him to come get the child. They called him. He went. Was in the process of gathering things. The officers went upstairs after serving the restraining order and explaining what was happening to the defendant. The shooting occurred. The end. So
That's a new story.
State getting into more than, or the jury really hearing more than that in the Commonwealth's case in chief.
Okay.
Subject to many of the motions that we have filed.
So
If the doors are-
maybe it makes sense to, let's start with paper 61 because this kind of segues into that. And that is the Commonwealth's motion to eliminate to prohibit questioning regarding custody status. And actually, when you say custody status, you mean both the child custody and the pretrial detention aspect.
I do actually.
Okay, all right. So let me first, before I hear from you, Ms. Moriarty, is there an objection to either one of these items in paper 61?
We don't expect to be employing anything down that road about custody.
either custody, about the custody issue related to the child, and about their client's
Well,
detention?
only to the extent of the contents of the order that's being put in front of her. And that, to the extent that it's just an obvious part of the whole thing is that,
Right.
you know, she's packing a bag for her baby, she's giving the baby to the police, to give to the father, just what's in the order. I think we're probably in good shape on that in the sense that we're both agreeing, we're going to stipulate to the order, I think, this, as an exhibit, and the order says what it says, and we're going to both use what it says on the order.
Okay.
So I think that's the extent that I.
All right, so obviously you can argue and question witnesses based on reasonable inferences from the order, but doesn't the order mention custody, temporary custody? Do you folks have, is there a copy of the order? And I thought I saw it on the file.
So I think just the custody post June 30th, 2025. So insofar as the child is still with Mr. Elaine, I don't see how that's relevant. That was really so the fact of the fact, we're not disputing the fact of the matter is the 209A order granted Mr. Elaine custody of the child that day. We just didn't want there to be additional on direct or cross of any witness, you know, the current custody status of the child.
Okay, I can't imagine you want that.
We don't.
Okay, all right, so, and then do you anticipate, Mr. Gradle, that you would raise your client's pretrial detention status?
Yeah.
All right, so then it seems to me that I can allow it without objection, as it is narrowly tailored. All right, so, just,
I think the Commonwealth just changed the story again, what Justin did at the house.
so then,
I need to get on with Lauren and have another show where we talk about what is said, because this makes no sense again.
that brings us to paper 62. Commonwealth's motion in limine to preclude questioning regarding current duty status. So let me be more specific. My understanding is that Commonwealth is seeking to preclude evidence regarding the Officer Newton's now current status with the North Andover Police Department?
Yes, sir.
Okay. And what is the status?
The Commonwealth's understanding is that he is on leave.
All right, so you would want to preclude any mention about that Officer Newton is on leave?
Yes.
Okay. What do you say, Mr. Prado?
Judge, I think that we're just talking here about perhaps putting this in abeyance until we get the IAD files, because we have a lot of information that I think we have more information than the Commonwealth, frankly, about his status, that it may direct this debate in a better way.
Yeah, maybe I just defer ruling.
I think that makes sense, and we can address all the issues kind of simultaneously.
Okay. So that brings us to paper 64, defendant, Commonwealth's motion in limine to admit prior bad acts if they become relevant. There's also some good acts on another motion, but go ahead.
With respect to the prior bad acts evidence, Your Honor, as captioned, the Commonwealth recognizes that those are not relevant to the Commonwealth's case in chief. However, in abundance of caution, the Commonwealth wanted to alert the court to evidence it had in its possession about prior bad acts in case they do become relevant based on opening, cross, or the defendant's case. So we can really hold those aside for now, but the Commonwealth just wanted to alert the court, and obviously, if the Commonwealth believed that a door was open, we would come up to sidebar before any questioning related to any of these issues.
Okay, so, and I appreciate that you're being careful. So the bottom line is you're not seeking, the Commonwealth is not seeking at this moment to admit other acts, but you may argue, as either side would argue during the course of the trial, if it arises that the door has been opened, and we'll have to address it at that time.
Yes, sir.
All right, so I'm not going to take any action
That's
on it.
fine.
No, that's easy. It will be deferred until is necessary, which brings us to paper 65. This is Commonwealth's motion in limine to preclude questioning regarding promises, rewards, or inducements. And I'll hear you comment on that.
And this is a subject that we touched on last time.
Right.
Just concerning the request for a promise, reward, or inducement. And so I think we're kind of in a slippery slope. If the council is able to ask the witness concerning post-events accusations, because these accusations that the defendant has made in unsworn statements and the like is going to muddy the waters. One thing that
But which accusations are you talking about? The accusations related to Mr. Elaine allegedly breaking into the house, or the accusations about purported favorable treatment of Officer Hernandez?
I'm sorry, this is the alleged breaking and entering.
Okay.
Because it is post what we're talking about here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that.
Hey, all, Cat Not Williams
Based on our
viewers.
prosecutorial discretion,
Thank you for the raid, Cat.
honestly, with our prosecutorial ethics, these are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false. Mr. Elaine was a resident of that home.
All right, hold on.
Yep.
I'm hoping that we don't have to relitigate or even litigate for the first time the alleged conduct. The bottom line is the Commonwealth is seeking to preclude mention, Mr. Bradle, of the events of this breaking and entering. Okay. And do you object to that?
So I don't expect this trial to go down this side road. But to the extent, I don't think Elaine really is a relevant witness in the case. Granted, he's on the premises, but he has marginal relevance. And I think that
It's kind of, that's what Mr. Kubikosi said at the last hearing, but you didn't seem to agree.
So,
Maybe
well,
you rethought it.
he's a dangerous witness, I think, for both sides. Let's put it that way. And so it's a complicated scenario, Your Honor, that, if he does testify, that opens cross-examination. That might open some other doors too. But, I mean, if it was me, I don't think I would call Mr. Elaine, because it opens up all kinds of cans of worms, and he has testimony that's only duplicative of other people. And, the fact that he's there on the premises, let's put that aside for a minute, that they let the guy who gets an order to have someone stay away from him, they bring him to that premises. Let's put that aside for a second. But he's like a straw man. There's nothing that he adds to the trial, and I'm going to cross-examine him, but I don't want to open up certain doors. So he's a very complicated witness. He's one of those kind of mistrial witnesses. So I don't know why they're calling him, frankly. But if they could, this is, I guess, my position. If they call him, then all bets are off.
So, I can't imagine that you're asking me to preclude the Commonwealth from calling.
No, it's not.
The Commonwealth has a burden of proof, and they're gonna, within the rules of law and evidence, though, they're entitled to try to prove their case just as just as Ms. Fitzsimmons is. The issue is, do you intend to ask Mr. Elaine, if he testifies, isn't it true, Mr. Elaine, that on such and such July, whatever date, you busted down Ms. Fitzsimmons' door, went in and, stole things and et cetera?
Yes.
Okay, we intend to ask that. And that's, again, understanding that some of this depends on what he says during direct, and I totally get that. But just from a 10,000-foot view, how is it relevant?
So he's getting special treatment from the government, Your Honor, and, he's been coddled and protected by the government from before the service of this order. There's all sorts, and talk about opening doors.
But why, in using your theory where he's this background witness, why would the Commonwealth be motivated to do that? And when I say the Commonwealth, the Essex District Attorney's Office be motivated to give him special treatment?
He's in with the right people, Your Honor. We would be able to prove that he's in with the right people. I don't want to give you too much, but I hope you're satisfied with the direction that would go at this point. And he's in with the right people. They knew this was coming. Ms. Fitzsimmons was at the police station the morning of this event, being treated fine, brought the baby to the police station, took a CPR class to refresh for her upcoming appearance on duty schedule. She was treated wonderfully. She saw her friends. She did the training. She passed the training. She had the baby there. People are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this. We have information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to give Kelsey her radio for July 4th." One of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now." They knew they were conspiring, to use the appropriate word. They were conspiring with Elaine.
Oh my God.
Before this service, for this whole thing. And there's an entirely
They
other
were conspiring. Oh, I thought
with
you said-
Elaine too.
I thought you said Elaine.
Yeah, I'm sorry, with Justin Elaine. They were conspiring with him that he was gonna go get this order, he was gonna communicate with them, they're gonna serve this order, and, not to put too fine a point on it, but there were many people in that department that didn't want Ms. Fitzsimmons to go back to work. And this served the police department's ends as well, to blow her up by serving this order in a certain way. So you see where I'm going, there's a lot of doors here, Judge. There's a lot of doors.
The doors are easy from my perspective, because it's about the rules of admissibility of evidence. So, it seems to me that, again, the narrow issue here is whether you get to cross Mr. Elaine on the fact that these facts related to his alleged breaking and entering, and from my perspective, it would only be relevant when you say special treatment is if somehow he's changed his story, right? So maybe some of this will have to hear his direct, but there would have to be some basis to cross him on it that he's somehow trying to curry favor by changing his story.
I think it also tends to explain the unorthodox manner of service of the order, Your Honor, in the sense that they let him go into the house. Okay, he's an adversarial litigant against the owner of that house. He just got an order against her. Keep her away from me, I'm scared of her. The police let him into her home. So there's all kinds of bias. There's all kinds of special treatment.
I have to say this from my perspective, again, that reading the transcripts of these calls that Mr. Elaine was making to the North Andover Police Department, I can't, to say that he was in with the right people, maybe he was on one date, but he was pretty pissed off on the date he was calling and, why.
Because he wasn't used to getting this special treatment he always gotten, and it fits the story entirely.
Because during those calls, he's saying that repeatedly that he's going to take it to a higher level, meaning I think somebody even asked him, what do you mean by that? And he said talking to the chief or something.
Because he
and
gives
how
him special treatment.
He's complaining that the North Andover police failed to protect him. All right, so, I'm not sure when we hear the Commonwealth, I'm not
A
sure.
lot of that is just the tip of the iceberg, Your Honor.
I'm not sure that I can rule on this right now. You can tell what my present thinking is.
Sure, and I agree with that. I agree. He made a statement. His testimony is going to be unless the defendant opens the door, very limited as to the presentation I made a little earlier. If his testimony changes significantly because of that, then it may open up to something different. But having said that, the Commonwealth decided not to prosecute. We're not promising anything. We decided not to prosecute for a specific reason because we believe there isn't a basis to do that, a good faith basis to do that. I can't reiterate that enough, but having said that, what does any of this have to do as to what happened in the room up there? Because if counsel is up here 1 minute saying it should be very narrow, very short case about what happened in that room between Patrick Noonan and the defendant, and then all of a sudden wants to litigate a different case about the corruption of the North Andover Police Department, Mr. Iolian's favorable treatment. Well, you can't have it both ways. It's either one or the other. And so that's what I'm a little nervous about now, is that, okay, we start this trial one way, and the representations have been made, and now we're taking it to a different place. And that's why the Commonwealth has filed that motion previously.
Okay, so here's the thing. I think where I come out is I have to defer ruling until I hear the direct, or if the Commonwealth were to otherwise open the door. So what I would say is just come to sidebar before you ask those questions, and because I don't, generally speaking, I express my view of it, but it wouldn't be fair of me to Ms. Simmons to completely preclude it without hearing the director any of the case. So that's my ruling. It will be deferred until. Sure. Yeah, sure.
Can I just say, just in response to what my brother said, I was actually going to use that against him, that they can't have it both ways. If you're going to call the witness, I get to cross-examine him.
I want to use that's why I tried to start the hearing with the agreement that I saw. That is that Mr. Gubitosi saying it was a simple case, Mr. Bradel saying the narrow issue here is it's a simple case, and I want to hold both sides to it. So,
I agree, and I just have a concern about opening doors, and I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. Judge, we're even thinking about making it simpler, and I know we still have to do with all this jury stuff. We talked about a possible bench trial. I don't know yet. I'm just saying, everything's on the table still. But if they're gonna call too many witnesses, I gotta cross-examine too many witnesses. So it depends on where they're gonna go with him, and he's gonna have his comeuppance in family court, and I don't think I really want to get into it too much here. And if the Commonwealth wants to call him, it's going to happen to the extent you are less. Thank you.
Okay, all right. So I'm going to, on paper 65, I'm going to defer ruling until trial, really until after Mr. Alayan testifies.
I'm not sure I would do this as a bench trial.
Defense should come to sidebar before asking questions related to that. Let me ask on something that Mr. Bradel just that I wanted to ask, but let's just march. I think we have one more motion. Commonwealth's motion to admit prior good acts. Yes.
Again, I think this would come up more in redirect than in direct of the conflict of Patrick Noonan. So I would just ask to alert the court that this exists, and if we feel it becomes relevant, we'll decide our prior to redirect.
talk just generally, do you folks, are there any exhibits that you folks think are going to be the subject of strenuous objections and litigation? And if there are, if you could just, let's just get out in front of them. All right. Sorry, something that Mr. Bradel just raised, I want to follow up on it, I just can't recall. We'll come to it. All right, so what that leaves is paper 73, which is, that was filed this morning at the base motion to modify the pre-trial conditions. All right, so it's paper 73, defendant's request for change of address. All right, so let's just make sure that we're on the same page, Mr. Bradel. And that is that you're seeking, there is an order in place now that the defendant reside at a particular address in Methuen.
Yes, sir.
With Warren and William Page. So you're seeking what?
So Judge,
To,
can we put a sidebar on some of these issues? Judge?
sure, absolutely. And if we're going to do that, this Fitzsimmons is going to come up as well.
Thank you very much.
Thank you. Sure.
So sidebar. So, yes, a lot of people heard what Bradel said. We haven't even decided if we want a bench trial. I don't think bench trial is good in this case because the way the statute is written, just waving a pew-pew is breaking the statute. I think you need a jury in here to feel sorry for her and say, well, she clearly was pushed in a wrong direction. They don't want Justin's drug history from the fire department or his disciplinary record because they see that as an attempt to just go fishing in his prior bad acts. So they don't want any of that in. I thought they said to begin with that his record did come in by agreement, but then it wasn't. They spent a lot of time talking about that as a way to be able to impeach him on the stand, but now both sides are saying they don't really want to call him because it'll be way too much of a potential problem he can start for both sides. The judge was asking, why do you want these records? It just looks like you're going on a fishing expedition, and that was denied. They were not allowed to get his disciplinary records from the fire department, as I understood it. Then there was some standard sequestration of witnesses, and that they talked to them not about the defendant and the victim or alleged victim or all of that, but they just use names. Whether her prior bad acts.
Well, let me just go back.
Go.
Because we were at sidebar. The Commonwealth objects. This would mean changing the condition to basically two conditions. One is to reside at a particular location in the Methuen, and second, to reside with Mr. and Mrs. Page. As far as I can see, those are the two conditions that this would impact. And Commonwealth objects to both. Does Commonwealth object to both, or to one, or to all both?
Well, there was a long hearing and a long history to this case. And one of the conditions that the defendant was placed under was that she would specifically live, I don't care what house it is, but with her family, with her mother and her stepfather. There was a colloquy with her mom that she would take custody of her and that she would oversee what she was doing and that she would report to probation if there were any problems. Now she's asking to live on her own, which I think is a marked change to what we've been doing for the past few months. She, in her affidavit, it's basically.
Well, so in fairness, all I wanted was a yes or no, no, that's fine. Because I want to give Mr. Grado an opportunity to argue this motion before you. I just wanted to make sure that there is, so it seems like you oppose both, or is it more the supervisory role of the parents?
Well, which resident, if they could move the entire, the family to another house, I don't care about that.
Okay.
You know, as long as probation is fine with it.
So, Mr. Grado, I'll hear you.
Yes, Your Honor. Thank you very much. So, Your Honor, you know, Ms. Fitzsimmons is a 28-year-old adult. She had this order at a different time in the case. And, you know, I'm not going to get into too much, okay, but this order was entered in very suspect circumstances. And I know what you're going to say, Judge, I'm sorry.
No, it's just not helpful because, but let me ask, come up, are you objecting to me hearing this motion?
Well, I don't think there's any changed circumstances, so I am in that regard.
Okay.
So.
But the concept of me ruling on the motion in the sense of whether there's changed circumstances, you folks don't object to that? Okay. All right, go ahead.
So Judge, she and there's actually another aspect to this that we're asking too, that kind of go hand in hand.
Sure.
And that is that we're asking also, I'm asking you to lift the restriction from the Superior Court, something I've never seen, where the Superior Court justice said that she can't go to family court and do anything. It doesn't matter what family court says about custody or visitation. The experts that do this, that's their core function.
Where does the order say
The
that?
order here is that she has to stay away from the child and that she, regardless of any probate court orders. I can't point it to you this very second, but it is in writing in one of.
No,
Yeah,
it's there.
okay.
I
So,
want to make sure that we're on the same starting point.
Right.
So we have a written motion on paper 73, which asks
Yes.
after the change of those other two.
right,
Orally, you're moving to vacate the order, so much of the order that says, let me see, have no contact or indirect with own child.
and only to the extent to say, subject to deferring to probate court. So subject to probate court orders, that's all.
Commonwealth,
Well, there's also a restraining order out there that has never been challenged at this point, so like.
but if, in other words, if I were to vacate that and make it, she's already, Ms. Fitzsimmons is already ordered to obey all orders, court orders.
I would leave that up to the board,
Okay.
as far as, I'd leave that to your discretion.
Okay, all right, so that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct with the child. And again, only because since the passage of a long time,
Yes.
we now know, because the Commonwealth provided dockets, that there is ongoing, at least a case has been opened related to the well-being of the child in the probate and family court. They're the experts. But I want to say that all that this initially did when it was entered was essentially ordering her to comply with the restraining order. Because the restraining order it wasn't Judge McCarthy, it was the probate court judge that had granted
The restraining
right, okay. So I will vacate that.
order. Thank you.
And
And I could just tell you, just so you know, Judge, the motion for temporary orders has been filed, and the hearing on that is 4-2. So it's probably after this trial.
can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket entries of the custody parenting case, but it didn't mention, that those docket entries didn't mention the restraining order at all. Is that because it was taken out under a different document?
Correct, Your Honor.
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents
Okay.
her
But
for
it's a
custody.
completely different.
Marissa? No, she doesn't get to see her baby today. It will still defer to probate court, but the Supreme Justice has made a ruling that she wasn't allowed to have any contact, no matter what probate court said. They can now go and try and change the custody agreement. So she potentially could have contact with her baby again if probate court deems it safe for the baby. She still has to abide by the restraining order. So it's not a win-win, but it's a potential to change it so she can again have some form of contact with her child, because the justice had said, no matter what probate court says, you can't see your baby. And that's what was lifted. So if probate goes in and say, well, you can have a video conference or video calls with him, or you can have supervised visits, or maybe even have a day with him, they can now say that's okay. According to the ruling that was on the case, no matter if probate had said, Justin have to give her the baby back. No, because she wasn't allowed any direct or indirect contact with her baby, according to the old ruling. He lifted that part of it. Then it's up to probate court to go in and figure out, okay, what are we going to do about this visitation, custody, whatever is going on. But they couldn't really file anything with probate according to that, because she had no right for direct or indirect contact with her own child. Yeah, so if probate says she can see him, the superior's ruling doesn't stop it.
That's why I wasn't seeing it on the document. All right, so.
And that date, Judge, just so you know, 4/14 is for the restraining order itself.
All right, so I'm going to vacate that, and Mr. Boyd, just remind me, I need to. So you've docketed the orders, the order of pretrial condition at 74 and this GPS at 75. So I'll need to just change those, but let me wait until I decide the other issue. Let me hear you on that.
Thank you, Judge. So Ms. Fitzsimmons is preparing to be able to offer the family court a viable, good situation for whatever custody visitation she can get. And she needs to do that in advance of the 4/2 and the 4/14 hearings, so that she can go to family court and say, you know, I now have a home, I have a good, you know, that's the first question the family court judge is going to say. Well, if I give you something, Ms. Fitzsimmons, where are you going to be? Where's the baby? And we want her to be able to say, not that I'm at my family home in my high school bedroom. I want for her to be able to say, I have a wonderful townhouse, plenty of room, fenced in yard, great situation, and I'm ready to go, Your Honor. And you know, we'll also proffer Dr. Zeisel's report that we have here for you, that this is a good thing for her, that this is something that is consistent with her very bright future. It's something that is appropriate. You know, this was a 4-month-old child who's now a year-old child, over a year old, and that this needs to happen for so many reasons, Your Honor, that I won't get into, but she needs to have a situation that's ready. And I think we have expert clinical evidence to show that in the present circumstance, she's ready for that. And we were asking the court to get on that bus and help her in this sense, so that she's ready when this is over with. She's ready. She's in the best possible position she can be in to go to probate court just a week or two later with this in place. If it's not in place, God knows it's a nightmare scenario, Your Honor, because I'm sure you know the probate court dates are like, you know, they'll without batting an eye, they'll set like an August 8th you know, and Ms. Fitzsimmons will be sitting here.
Honest of what
You know, that's the point. So it's a very difficult scenario. We're just trying to get all of our ducks in a row as best we can. And this would be something that I don't think asks too much. And, you know, she's agreeing, and you see in her letter and in my motion that she's saying, I don't want my lawyers to disturb any of this other stuff, you know, about house arrest and scram and, you know, the 2-hour notice, which we appreciate very much, to come see us. She doesn't want to disturb anything else. She just wants to change her address and live like a grown-up.
So can I ask something, Mr. Gradle, then? So there was much litigation prior to my involvement related to the alcohol testing, smearing testing. And why isn't alcohol use mentioned at all in Dr. Zeisel's report? I think in either of his reports.
So, because it's something that, and I'll give you my real answer,
That's all I want.
it's something that was imposed on her to stick it to her, to punish her, Your Honor. There's no alcohol whatsoever in this case. There's no pattern of anything. It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that scram device, Your Honor, and I'm furious about it, so I'm sorry, but talk about, you know, you got me on that one. I'm furious about it. It's baseless, is my answer, sorry.
All right, so leaving aside your argument about whether it's baseless or not, I mean, I can tell you that I've read all of the impounded documents that the judge relied on in fashioning the order, and alcohol was mentioned by Ms. Fitzsimmons' own friends that were at that. So now let me say this.
At one party.
So my only point is that it's. So your position basically, actually you answered it. You're basically Dr. Zeisel didn't weigh in on it because he presumably doesn't think it's an issue.
And he's here, Judge, like I said, if you want to put him under oath and hear from him, I'm sure Dr. Zeisel will echo everything I'm saying about how there's no evidence, nothing's evident about any alcohol issue in terms of, you know, at a bachelorette party, a week or a few days earlier, whatever, fine. But as a basis for long-term, you know, monitoring is outrageous to me. And the only other thing in the record, Judge, talk about a reach, 2018 in like Myrtle Beach or something.
Yeah.
And that,
This isn't helpful.
and that was expunged.
I realize that I kind of opened the door.
I'm sorry. He's here, Judge, if you want to hear from him, you can get some more evidence on it. You know, the alcohol issue really is not.
Thank you. I've been well, how about you?
I've been excellent.
That's great.
I should say one last point, Judge, I think you missed. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. She doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is infuriating. I'm sorry.
No, there's nothing to be sorry about, Mr. Grado. You're an advocate, and a good advocate for your client. And the judge asked you, and you answered, and when the judge asked you, then he didn't want to hear the answer. I get it. So, but the point is really, in all seriousness, the point is you're not seeking to change the scram.
Right.
Right? And so, can you just tell me, how does the scram work? Is it random or is it? Probation. Hi, how are you?
Good morning, Your Honor. Well, good afternoon.
Yeah, come on up. And you are again?
Alexander Hunt for probation.
I'm sorry.
Alexander Hunt.
Hi, okay. And do you want to swear her?
Would you raise your right hand? Do you solemnly swear to make true answers to such questions put to by the
Stop
court or
touching the microphone.
Self you God?
Thank you.
Thank you.
I'm sorry, I don't think we've met before.
I don't
Before this
think so.
morning at the other here. Officer Hunt, are you supervising this Fitzsimmons?
I'm not, Your Honor. It's P.O. Scrunchy in Salem.
Who is it?
P.O. Scrunchy.
How do you spell that?
SCRUNCHY. ENCI.
All right, another officer that I'm not familiar with. So what is the report back? Has she been in compliance?
She has, Your Honor. She was 7 minutes late to curfew on March 10th, but she had informed Elmo ahead of time, and points show that she was stuck in traffic coming back from an attorney's appointment. She also missed 2 scram tests, but then passed the immediate on-demand test. So she's passed all her scram tests.
Okay.
So other than those minor incidences, she's been in full compliance.
And the scram, how does it work, or how is it working in this case? Are they random?
They are random.
Okay, so what happens? Does something go off on the device or something?
That's correct, Your Honor. A noise alerts her that a test needs to be taken, and then she has to take the test.
Okay, is that something that, again, this is more intellectual curiosity, because I haven't really had the opportunity to learn about how exactly the scram device works, but I think it's important for me to know, because it's one of the more significant parts of the pre-proclamation work. But what happens for the notification? Is it the GPS monitoring bracelet that goes off that tells?
Those are separate, Your Honor,
They're
but
separate.
Elmo supervises both of those.
Okay, so what happens, how does Ms. Fitzsimmons know that it's time to do a scram test?
It alerts her, a noise goes off.
So, and what is this device? The device is a breathalyzer or something?
Essentially, yes, Your Honor. There's a straw that she has to blow into. It takes her picture so it knows it's her. And that's how, and then via like Wi-Fi essentially.
So does that mean that she has to have that with her when?
At all times.
Okay, so when she leaves to go to doctor's appointments?
Yeah, so Judge, I got it right here. It leaves from 7 a.m. to 11 p.m. all the time, and she blows into it, and it took her months to be able to blow into it without a lot of pain, and she can do it now because her rib is healing up. Her rib was blown apart in this shooting, and she can breathe now, and she can do it. And it gets on her from 7 in the morning till 11 at night. And it also has a GPS component to it as well. So she's on double GPS.
Roughly, I know it's random, how many times a week do you know that it asks? Is there?
I'm not positive of Ms. Fitzsimmons, but I believe probably there's around 50 tests every 2 weeks. I believe she has many random tests a day as ordered.
Judge, I think it's for Ms. Fitzsimmons, I think it's about 4 times a day it goes on.
And pass for flying colors as far as you.
Correct, Your Honor.
Good, that's good. All right, Mr. Gradle, is there anything else anything else on Officer Hunt that I should know about her performance on pretrial conditions?
No, Your Honor, she's been in full compliance and in communication with probation.
All right,
So she's been a great probation judge. I appreciate you inquiring about that on your own. And, you know, it's just a step in the right direction for her. It's not a lot to ask. It's something that I know based on my interactions with her over the last 10 months, that, you know, she's very motivated to not do anything in contravention of the court.
so what is, actually, I'm not gonna ask you this because I know what the answer is. Mr. Kubatowski or Ms. Moriarty, what was the purpose of ordering Ms. Fitzsimmons to be in a custody, or to, really doesn't say custody, to reside with Lauren and William Page? But
Well, I can't speak for Judge McCarthy, but I was there. This is not something that I agreed to, I encouraged or anything like that.
right.
It sounded like that, because of the situation in its entirety, including a statement from her high school friend that she's had an alcohol problem and an aggression problem since then,
I saw it.
that the judge thought it was appropriate for the mother to monitor her. So she made sure she does everything, including making sure there's no weapons, no dangerous weapons, nothing in the house that would be considered dangerous. And so that is what Lauren Page, the mother, had sworn that she would do. And I think that answers your question as best as I can answer it.
Okay, and tell me about your objection.
My objection is We're all glad she's doing well, but why are we gonna mess with it at this point? We have a trial in 10 days, which is gonna be a very stressful time in her life, I'm sure, that we're coming upon. There have been no change in circumstances to suggest that, no real change in circumstances to suggest that this is an appropriate reason to change anything or a time to change anything. I think all that could happen here is we mess something up and it messes with the trial date. Or she hurts herself or she hurts someone else. That's what this is about. These conditions were put in place for a reason. I would suggest they were ultimately fair. I just don't understand why, if in her letter to the court,
By the way, Mr. Green, did she sign that?
Yeah.
Okay.
her primary reason for this request is in preparation for my identification of my child. We're talking 2 weeks. 2 weeks from the time of today to basically, we could be finished if it's a streamlined trial. If it's not broke, let's not fix it.
Well, but from her perspective, it is broken. That's what she
Sure,
said.
in my perspective and from the unbiased really look at this, it's not broke. She's doing everything the court has asked her to do, which she should be doing. And so what's the changed circumstances at this point?
That she's in compliance and doesn't drink.
I point to Dr. Zeisel's report, her letter, the passage of time, the fact that we're in a trial posture, and sort of, maybe why don't we analogize it to, when someone asks you to remand a guy from Pittsfield to Essex County House, it's like counsel for the Commonwealth is answering my own question, which is, it's a stressful time because she's in a difficult situation and it's hard for her to prepare. If she has her own home, it's much easier. She can come and go. She has the whole place. She can focus on other things when she wants. It's just I don't want to make too much of it, Judge. She's just going to go to an appropriate home, and it helps her in her family court efforts. That like I said, I don't want to get pushed off months and months if we're not ready on that occasion. So
I'm sorry, but what?
I'm alluding to what I mentioned earlier, Your Honor, about how on the 2nd and the 14th of April, we're going to be in family court. And I want to be able to say that she's been in her house for a couple of weeks. She has a great situation. She's been setting it up. And, it'll just take a lot of the, it'll uncap the tea kettle and a lot of steam will escape here if she can just kind of be in her own place.
Right, that would be grounds that would support my revising or modifying those two conditions. But I can say that I think the teachings of the SJC's cases under 50A often are that the passage of time can be a changed circumstance. And here, there is arguably a changed circumstance because Dr. Zeisel has said that her mental health has improved significantly, because my memory is that in the first report that Dr. Zeisel wrote that's in the file that's impounded, he did imply or mention that she didn't contest that she had been suffering from mental health concerns at the time.
Yes.
And directly after. So I do see, I guess the long story short is I do see sufficient change in circumstances. The question is whether the supervision by her parents is something that I would change on this record. And so does Ms. Fitzsimmons have an address in mind?
Yes, Judge, it's all set, even the lease is signed.
When would she move?
As soon as you're ready, Judge. She has custody of the place. Whatever the work is, she's ready to go.
And
it's in Essex County, and certainly will give you the address, obviously.
right, and she's amenable to having probation inspect the place prior to her move. Yes.
Yeah. Oh, absolutely. I think that's a good motion.
How about if I were to order visits to.
No objection.
To ensure compliance with the no weapons and
Sir,
et cetera.
no objection.
Sorry, Officer Hunt again, come back up.
Come on now, give it to her.
So, tell me, if I were to order, some kind of a visit by probation before, the defendant were to move into the location to make sure that, it is a place that, at least from what, is observed, that, it doesn't have any weapons, to see what exactly were. No weapons brought into home, so weapons being pretty broad. Is that something that the probation department can do?
Absolutely, Your Honor.
And how about, I know that home visits happen all the time when someone is on post-trial probation. Is it something that you folks see occasionally, at least on pre-trial?
I'm aware of one case we've had where we have done it, so I believe it's possible, but I would like to double check with the supervisor. As for the home visit, that could be done, the initial home visit to check, we could do that by the end.
Is Officer Scrunchy available for, at least maybe even for you to communicate with about that aspect?
Yeah, I can contact her right now.
So it seems to me that, and again, I don't want to go back and forth on this. I read all of what the original judge had before her, and all of these orders were well supported. They were orders that I would have issued at the time. They're orders that a single justice affirmed. They're orders that the SJC affirmed. I don't want to relitigate that, but I also believe that there's sufficient grounds to consider allowing the move and allowing the termination of the supervision, I guess, or the residing with the parents, so long as the probation department could monitor, and it would be by surprise monitoring. So, Officer Hunt, I don't know if you heard that. So I want these visits to be a surprise.
That's no problem, Your Honor. I also just spoke with my supervisor, and she said as long as it's a court order,
Either side want to be heard any further?
Judge, I say that her PO is aware of this request and it's been discussed, and I shouldn't say that she agrees with it. I just said that she's fine with it in the sense of whatever the court order, she's happy to implement.
Anything else, Kamala? Okay, I'm going to allow the change, subject to an inspection by the probation department prior to the move, Ms. Fitzsimmons' move being physical move into the new place. And the inspection will be for weapons and also alcohol. You may as well look for that. And it will be subject to inspections, random inspections by the probation department. I think what it may make sense at this point is for me, which would also mean that the GPS supervision conditions would need to be changed. I think it makes sense, Officer Hunt and counsel, for me to just issue a new order, and rather than write on this, I would carry over all of the orders. No, you know what? I don't think it's necessary. Do you have do you want to have the sidebar on the address? Or is it something that you can provide?
I just provided it to probation, Judge.
Yeah, but I need to keep sure. Everybody come on over to sidebar, please.
Finally, just skip ahead, Marissa. Just skip ahead. We're behind. Finally, something positive for Kelsey. She's now allowed to move to her own home, and she, as I understood it, will not have to do the scram device 4 times a day. She will be subject to surprise visits and inspections of the home, and the home has to be approved before she moves into it, which will mean that she can now go to probate court and say, I have my own home. I live in Essex County. I have all of this ready. Please, can I start seeing my kid again? I don't know what's wrong with this judge. He must not be from Massachusetts. I believe they took the scram off, yes.
All right, so I am going to allow that modification for the reasons that I've already described, both in open court and at sidebar. I need to just write it up. We'll impound the new address. I'd ask all counsel, as I said at sidebar, to continue to keep in mind that we want our jury pool to be as made up of as indifferent of a group of folks as we can. And that's what my expectation is going forward. All right, so I need to change that. Anything else, folks?
I filed another final certificate of fine, so I'm expecting any moment council's reciprocal discovery.
So, when you say, is that something, so is it something that I need to weigh in on, or are you just making a record?
Just making a record.
And I'm sorry, I missed it, Judge.
Mr. Gubertosi reported that he filed a final certificate of compliance under Rule 14, and that he's hopeful that.
I think we're there. I think we're there. There's a couple little things, but I'm not going to make any sure.
All right,
So
so.
work on it. Thank you.
All right, but also I need, I appreciate the sending of the joint witness slash prominent names list, but there's a bunch of names on there that don't have towns or cities associated with them.
Yes, as counsel said at sidebar, there's a safety concern in this case based on things that have happened, so I will get those to court before the trial.
All right, so, but how do we handle, I want to provide enough information for the potential jurors to look at that list and say whether they know a person or not.
We'll get a town.
Okay, and then, but are you suggesting that that be impounded?
No.
Okay. So, all right, so the missing, you folks will get, will run down the missing cities and towns of the folks that don't have them on that list.
I have them, but I'll supply them to the court.
And Mr. Brado, given how close we are to the trial, and with Mahmoudi, when you said that something to the effect that there was a couple of little things that perhaps, the bottom line is, are you prepared now to disclose whatever it is that you're required to
Yes.
disclose?
Yes.
And I'd ask you to do that as soon as possible so we can keep the trial on schedule.
Sure.
All right, and let me just see if there's Mr. Wayne. So, in a perfect world, we reconvene to talk about the juror questionnaire. Which we could. So are you folks, would you folks be available Monday afternoon? By then I disseminate the draft juror questionnaire. That's all that we would go over. And you, Ian, hold on, I'm sorry. Ian, you could appear by Zoom if that would be easier for you folks.
So if we're only doing the questionnaire, yes, that's fine.
Available, yes.
All right, so in other words, no surprises from the Commonwealth.
No, I'm not expecting any.
I can't, we'll all be surprised if there's surprises. All right, so that means I have some work to do, I need to get that out to you. Mr. Boyd, you have their email addresses?
Yeah.
Judge, did you say 2 o'clock Monday? 2 o'clock.
Whatever Mr. Boyd said, so. All right, so I need to, I'm gonna step off, I need to write up, the change conditions, which I will do if you want to just, hold tight.
Thank you.
2 p.m. this Monday is the 8th. All right, so we'll stay on recess and see you then.
Court will rise. We'll stand in recess.
What a wonderful day in court. What a wonderful day in court. We have been used to being angry and teed off a lot when we have been watching these hearings because the Commonwealth is shady. The judge has been an asshole. Now we have a new judge who seems to be a human. He must not be from Massachusetts. Kelsey will now be able to start her new life. It won't be a good start of a new life because this is a horrible, horrible thing that still happened to her. But she's now allowed to move out of her parents' house and into an apartment as if it is checked and cleared by the probation officers. Oh, that's Aiden. She will be allowed to leave the scram device that goes off 4 times a day, and she has to randomly blow into a tube to prove she's not an alcoholic, even though there has been no other proof of alcoholism other than she was drunk at a bachelor party, according to one witness, and she might have been drunk in high school. And this judge did the only thing. The judge did what he's supposed to do. He altered the bond conditions, so now she can also go to probate court and try and get some kind of relationship back with her baby, who she hasn't seen in more than half a year. Because the restrictions put on her that she had no contact at all, no matter what probate court said, was so overly broad and just so unfair to tie her on her hands and feet in that way. This is the beginning of a new beginning. It's nowhere done and everything is fine and everything is hunky-dory. The fight for having her child back has just begun. But this is a big step because they will look at probate court at what are your living conditions, what distance do you have to travel, and all of these things, and what is your daily situation. And clearly this will change a lot compared to what she had before, where she was living in a room in her parents' house. Is it all hunky-dory? Absolutely not. She's still facing this criminal charge for attempted aggravated assault against a police officer. she still have a long fight in the family court system against someone who is very, very well connected and has way too much pull, it seems like. If Turtle Boy was single, no, don't say that. Don't, because that'll just make all the insane people start attacking her. Why not supervised visits? Because, as I just said, the Supreme Justice had said, no matter what probate court said, you can't abide by it. You have to have no contact with your kid. So they haven't sought any, because they could have gone, probate court technically could have gone and said, no, you get custody of your kid. And because of the court order, she would not have been allowed to have custody of her kid, because it was tying her on hands and feet. She was to have no direct or indirect contact with her own child. That's how tight that order was, which is absolutely BS in my opinion. No, I haven't watched Aiden the video of Aiden phone being knocked out. I have been streaming for the last almost 4 hours, so I don't know. Yeah, there's enough people out there, and imagine if these idiots who will do anything to ruin anyone who is mentioned in any connection to Aiden start believing that. That will just make more problems. While I was sitting here and looking around, I saw that Untwisted Tragedies was pumping her fist like crazy when the state won that they weren't to turn over Justin's papers. And I'm just thinking, what the hell is wrong with you, you fat, obnoxious bitch? I'm sorry, it's a good Christian channel, but she's a fat, obnoxious bitch. Because everyone can see this is way out of hand. Why are you supporting the state in this case? The only reason why she is team state, team Commonwealth is because Aiden and Bradel, or they share Aiden and they share Bradel as a lawyer. That was what I'm trying to say. I've been streaming for 4 hours. Yes, I say dumb stuff now and again. So these wretched, insane women who will just hate on her because she's way hotter than they are, way more successful than they are, and because she's connected to Turtle Boy, they really effing need to grow up and get out of that headspace. I'm sorry. You're doing a great job for us. I don't care what Zach says. Well, anyone who listens to Zach should be tested. Probably be in an institution because, yeah. Yeah, the only reason is because of Bradel, and Bradel is connected to Aiden. If Bradel wasn't Aiden's lawyer anymore, these women would be sitting there and saying, oh, Justin is an asshole. But no. Can't do that now. So, yeah. She hates Turtle Boy so much she roots for the devil. PDS and TBDS have the same symptoms. Yeah. My opinion, people need to boycott the haters. I made a decision 2 weeks ago. I'm done covering. Of course, sometimes some will be up. I'm not going to sit here and cover the Hood Boogies trial coverage, where all they did was showing Mike's stream. Mike, who is not on screen, which actually is against TOS. But hey, enough about that. I'm not going to cover that because their massive legal insights is probably way better than mine. They have more experience with the system. I'm done with that. I was looking into some of the foreskins videos, but it was just so dumb, and I don't want that. I'm trying to get out of all the Massachusetts ratchet and trying to get back on where we were a year ago, where we were fighting to try and shine the light on all this craziness, and at the same time also maybe make a community again, make new friends. I will have to reach out to Lauren and have a talk about this because, again, I don't know Kelsey Fitzsimmons, but we've been covering her for so long, so it's a little bit emotional to see her like that in court and thinking, yes, as a father, this hurts my heart. I got divorced when my youngest kids were 4 months old. I know how different my relationship is with her compared to her sister, who I was with the first 2 years of her life. There's a lot of bonding that will never be the same, and we know this if you look at behavior, child development psychology. We know these are so pivotal months in a baby's connection to the mother. She will never be able to fully fix that. She will have to have a lot of time and a lot of work with this baby to try and heal it. And that's the worst part, because no one is thinking about the baby, in my opinion, when they just said, well, that fuckface can take the baby. And now they changed the story again, that Justin was in the house when the officers went upstairs before the pew-pewing. That's again a different story. He was called to the house, and then one of the officers went downstairs because Kelsey asked him not to be there. Again, maybe I need to bring Emily C. on and ask her to make a timeline, because this timeline changes all of the time. He will have severe attachment disorder. Well, I'm not sure he will have a severe attachment disorder. I hope they have been giving him a lot of training so he would be in a good place. It's really important that they get facial recognition and all of that. But she left a person who was breastfeeding. She left a baby. She's going to have a child now. It's not a baby anymore. It's not her little baby. This is a kid. You all know this if you have children. There's a period where they're babies, and then they become children. And that's around that 10, 11, 12 month. Something changes. That's when they begin to try to speak and move around and all of that. She has missed so many firsts with this baby. Is Justin super good looking? I honestly don't know. The picture I've seen of him, he's sitting in a hot tub looking sexy, but he has a mustache and he smokes weed. I'm not gonna date him. You can have him if you want him. I will not try and get in his pants. You call them toddlers? Okay. My granddaughter is a baby's age, and she has missed so much. It's heartbreaking. Yeah. Baby Baker is roughly the same age as well. And the last 3 months, because that's why I want to move, so I can see him more, because I don't see him enough. And it's every time I see him, it's just another leap that's just so insane. My son just switched from baby to toddler. It's a huge jump. So sad that the state is failing Kelsey. Yes. So, yeah. Let's just say he must be good in bed because he's not doing anything on the ice. Well, always remember to close your eyes. It stings. But that was Kelsey Fitzsimmons for today. I will go back and cover the rest of the hearing from Utah. Thank you all who came in for watching. Kelsey, say thank you to Marissa because I have this stupid geolock on NBC 10, and she's the reason why we were able to watch it together. And I have the best mods on the planet. They yell at me a lot, but I do like them sometimes. So please say thank you, Marissa, because she's really been a lifesaver today. So you could watch all of this. But for those of you who are on the way out, thank you for stopping by and choosing me for your Kelsey Fitzsimmons coverage. I will try, and I have to talk to Lauren. I need a show where we are talking about this, and we have to digest it because this is a big old day. But thank you all so much for stopping by, and I will go back to Utah while I go out and make myself some dinner because it's almost 6:00 my time. But the trial we'll go back to is did she unalive her friend with insulin, or did her friend have Münchhausen and